Good afternoon, everyone. Can I wish everyone a warm welcome to today's joint CLLS and SRA symposium on the Solicitors Qualifying Examination, which we all know, of course, as the SQE. For those of you who don't know me, my name's Ben Perry. I'm a partner at Sullivan & Cromwell, based in the London office, specialising in M&A. I'm also the firm's UK graduate recruitment partner and training principal, as well as a member of both the main committee and the training committee of the CLLS. I'm joined today by Julie Brannan, who is the Director of Education and Training at the SRA. Julie has, over the past several years, been very engaged with discussions with the CLLS Training Committee about the design, introduction and implementation of the SQE, and I'd like to thank her for taking the time to be with us today. We're obviously holding today's session against a backdrop where, while the SQE is being introduced in September of this year, many of the people at firms who are responsible for those firms' trainee programs have spent the past year with their hands full dealing with the challenges of the pandemic and the switch to remote working. So I think it's fair to say that while everyone is generally well aware of the upcoming transition to the SQE, firms are at different stages of readiness when it comes to implementing that transition, and not every firm has decided exactly when it should transition. Today, Julie's going to give a short presentation setting out where things stand in terms of the timing and next steps in relation to the implementation of the SQE. However, what we also want to do is make today's session both interactive and relevant to every firm who's taking part today, no matter what stage of the SQE process they are at. And we're going to do that through the Q&A. And what I'd encourage everyone who's taking part today to do is to submit their questions by clicking on the link below the video on your screen. We've had a number of questions come through before we came online today, and I'd like to thank everyone for submitting those, and we'll be picking those questions up as we go along. Questions can be submitted by clicking on the link at any time during the session. There's no need to wait for Julie to finish her presentation. When you send the questions, they'll be visible only to me, Julie, and the moderators via a meeting chat that we have running. You can include your name with your question if you would like to, and if you include your name, we'll assume you're okay for us to read it out. But you're also more than welcome to submit your question anonymously. And when Julie has finished her presentation, I'll then be walking through the questions that have been submitted and putting those to her, and she'll respond. As you'll have seen from the link that you clicked on to join today's session, this session's being live streamed by YouTube, and we also expect it will last for around an hour in total. However, as well as being live streamed, it's also being recorded, and a link to the recording will be shared with you in the coming days. And we'd encourage you to share the recording with others in your firms as appropriate. And with that, I'll turn it over to Julie, who's going to take us through the short presentation that I mentioned before.
Lovely. Thank you very much indeed, Ben, and hello everybody. I'm starting with our first slide, which is a familiar slide I'm sure to some, if not many of you. It's just a reminder of the core elements of the SQE and the admission process post-SQE. So as everybody knows, what SQE offers is a single robust examination where everybody is assessed against the same consistent high standards, and regulatory focus shifts really from specifying particular routes to admission or particular inputs to being very much focused on assuring standards at the point of admission. We are absolutely on track for introduction of the SQE on the 1st of September 2021, which is when the SQE regulations will come into force. Just running through the four elements, everybody will have to have a degree or equivalent qualification. They will have to have passed SQE1 and SQE2. If they are not already a qualified lawyer, they will have to have 2 years full-time equivalent of qualifying work experience, and they will have to meet our character and suitability requirements. Now, those are not in any chronological order. All of those must be met by the time people come to admission. The only timing rule is that SQE1 must be passed before candidates can attempt SQE2. And one point of detail on the suitability requirements, one point that in relation to suitability requirements is whether people can, whether that can be assessed at an early point in the process if somebody has a query about whether or not they have a character and suitability issue, and the answer to that is yes. There will be an opportunity for people to raise that with us early, as at the moment, although the formal decision on character and suitability is at point of admission, as it is at the moment. So number one, people have the opportunity to rehabilitate themselves over time if there has been an issue, and number two, obviously we need to pick up everything that's happened by the point of admission. Now, we've got a couple of questions coming through around what counts as qualifying work experience, and I'm going to pick that up later because we've got a slide on qualifying work experience. So if I can move to the next slide now. This is just a reminder of where we are now. So throughout the winter of 2020 to 2021, we've been doing a lot of work to put greater detail out on our website. That's all happened, and in fact there's a lot of detail about qualifying work experience there, and if you haven't already had a look at that, please do take a look. We've also been developing academic processes and policies, and those have been published too. We have now got our first live applications available on the SRA website, so qualified lawyers can apply for exemptions. Qualifying work experience can also already be logged, and the SQE website, and the third application I should say is that degree and equivalent experience or qualifications can be claimed for, so there's a process for applying for those. About 2 weeks ago, I think it was on the 11th of May, the SQE website was launched. That's where all the direct information about the SQE itself is stored, and in due course it's through that SQE website that people will register and then book to take the SQE. Information about SRA processes like qualifying work experience or character and suitability or admissions processes, that will continue to be on the main SRA website. So that's the split. The SQE website is for information about the SQE. The SRA website is for the other elements that need to be made out by point of admission. The next step is for us to open SQE assessment registration and bookings, and over the summer we'll also be putting out more detail about our approach to data publishing. The SQE regulations will come into effect on the 1st of September, as I said a moment ago, and then we have the first SQE1 sitting in November, it's the 8th and 11th of November, and then the first SQE2 sitting in April. So moving on then to the next slide, the opportunities. I think the critical thing here to bear in mind is that we have opened some doors, particularly around the flexibility for qualifying work experience and around the flexibility in terms of how people train. The standards remain the high professional standards needed for safe practice, but in terms of developing those standards, there is now greater flexibility through the new system. And this is just a reminder to everybody of the words really of the Bridge Group around the fact that in order to take advantage and to reap the benefits of SQE, it's important for employers and everybody involved in the system to take advantage of those new flexibilities, particularly around recruitment, where you're recruiting from, where you're going out to recruit candidates from, different recruitment methods. So you may have apprentices and paralegals and trainees working all towards future qualification as a solicitor. But also the other opportunity, which is that we have regulated the core requirements for practice as a solicitor, and that gives employers a far greater opportunity to flex training in line with your business needs as well. So the particular technical elements of legal practice that you might need, the areas of law, as well as wider skills. So that's something which is a greater flexibility so far as you are concerned. So moving on then to the next slide. how are law firms preparing? What are we seeing out there? What I'm very glad to say is that we are already seeing people take advantage of those new flexibilities that I mentioned in the previous slide. We've got our #ready campaign, and that's looking at two elements. It's looking at compliance, so it's putting out information about how to comply with the new regulations, but also how to take advantage of the new regulations. And each month through our SQE bulletin, we are putting out little case studies of different approaches to recruitment and to training, so people can see what other organisations are up to and see whether that sparks any inspiration so far as they're concerned. Obviously, we're aware of the City Consortium. I think some of those members are here today, and they've got their SQE preparation programme, which is at a very developed stage of preparation. We're also seeing graduate apprenticeships. So the apprenticeship route is being used for two purposes. First of all, 18 plus recruitment, and we now have over 700 apprentices on programme. We'll see very small numbers the first year. I think we've probably only got a handful of people coming through the apprenticeship route in the first year of SQE, but that will ramp up quite quickly to about 400 potentially candidates a year coming through that route. So a lot of school leaver apprentices coming through in due course, and also the graduate apprenticeship. So it's possible to jump in to the apprenticeship route, and we've seen a number of employers offering a combined qualifying work experience and SQE1, SQE2 training package for people who already either have a law degree or who are non-law graduates. So there's that opportunity as well that we're seeing coming through. And if there is anybody out there that would like to showcase what they're doing, then we've put that little bullet on the slide, so you know how to contact us, and we'd love to hear from you, to hear what you're doing too. So that's what we're seeing at the moment. And moving on to the next slide. This just expands on that I do think that particularly the professional legal training organisations have stepped up a lot in terms of the variety and choice of training which is available. There will still be traditional classroom delivery, but we're also seeing a lot of online courses, and the online courses which are being offered have this opportunity really to tailor training very much to the needs of the individual. They can go at the pace of the learner. They can feed extra materials through to the learner who perhaps might be struggling with one aspect or another. So there's a lot of innovation that we're seeing now in that space. We're also seeing greater integration between classroom and work-based learning in the way that, for example, I've just described through the apprenticeship route. And we're seeing both short focused courses which tend to be offer greater value for money, much more focused on what is needed for the SQE, but also programs which are are much broader, which add in the skills or extra legal subject areas as well, and obviously the different trainee, apprenticeship or paralegal routes too. So that does mean that we're seeing greater collaboration, I think, both between traditional universities and providers of legal education and involving law firms. We've seen some new entrants to the market come through. So you will be aware, obviously, of Barbary coming over from the States, and also the College of Legal Practice, which is the preeminent provider of legal professional training in Australia, and other entrants too, some of whom have a good track record in terms of the Qualified Lawyers Transfer Scheme. So we're seeing quite a lot of activity, I think, in the training market. We're also seeing quite a lot of price competition, so quite varied price points. At one end, we are seeing SQE1 and SQE training packaged at around sort of £3,000, up to full all bells and whistles degree programs at about 16,000. So really quite a broad spectrum of price points and quite a lot of price competition coming through. We're also seeing the providers, I think, working quite hard in terms of the funding offer to candidates in particular. So they are, we're seeing providers offering private loans, offering instalment plans, and so on and so forth. So people thinking quite carefully about funding as well as bottom line cost. So let's move on now to the next slide. And this does take us on to qualifying work experience. So the position in relation to qualifying work experience, and starting with the headlines, are that it can be obtained in England and Wales or overseas. But if it's overseas, it must be confirmed by a solicitor of England and Wales. It can also be obtained more flexibly, either in a single organisation or up to 4 different organisations. Now, what is QW? And this comes to some of the questions that have already been raised again in the chat. It's very clear in our regulations that qualifying work experience is experience of providing legal services. So one of the questions which have been raised is, well, what about back office services? And I think our guidance in relation to this would be that qualifying work experience for the individual, it should involve the individual in offering legal services. So you will have all sorts of other roles in your organisation. You'll have people in the finance department, you'll have HR professionals, you'll have marketing professionals, somebody in a training role in those those parts of the organisation is learning how to be a marketing professional or an HR professional or a finance profession. The purpose of qualifying work experience is to provide somebody with the opportunity to develop the skills needed to be a solicitor, not a marketing professional or an HR professional. So the guidance would be that providing somebody should be involved in legal services at a personal level, not just by virtue of being employed by an organisation which itself offers legal services. So that's, I hope, some further guidance on that. As the slide says, you know, it's 2 years full-time or equivalent, and it's to develop some or all of the competencies, and it's to be confirmed by the COLP or a solicitor. They're not signing off competence. It's not an assessment of competence. We do that through the SQE. It's QW is a developmental process. It's an opportunity to grow and develop as an aspiring future solicitor. And as I mentioned at the beginning of this brief presentation, qualifying work experience can be picked up at any time, and so we have that facility already available. So a candidate can log onto our website already and log their qualifying work experience. The advice that we're giving to candidates is that they should get their employer to sign off or to confirm that qualifying work experience ideally before they leave the organisation, and that's why we wanted that facility to be available now, even though the regulations are not live until next September. So that's the position in relation to qualifying work experience. If we move on to the next slide now. Now, this is looking at the position for qualified lawyers. And the first thing to say is that our definition of a qualified lawyer is somebody with a professional legal qualification which confers practice rights. So by way of example, that would not include a barrister who has not done pupillage and got advocacy practice rights through the BSB. So it is somebody who's fully qualified and has got those practicing rights. And the key thing about somebody who is a qualified lawyer is that they do not need to do, they need to do SQE 1 and 2, they need to satisfy character and suitability, they need to have a degree and equivalent qualification, but they do not need to do qualifying work experience. That's the position on that. And the They can apply to us for exemptions where their qualification or experience are equivalent. That is, they're not substantially different in content to the and standard to the SQE. We've already gone through that process in relation to exemptions for solicitors of Northern Ireland and Ireland who are, as at present, exempt from at the moment they're exempt from the whole of the QLTS. They will, once SQE comes in, be exempt from the whole of SQE 1 and 2. For Scotland, where Scottish law is more different than Irish or Northern Irish law, they are exempt from SQE2 because the practice rights of a Scottish solicitor are very similar, or identical to the practice rights of an English solicitor, but the substantive law is different, so they do need to demonstrate their competence in English and Welsh law through SQE1. The slide then says a possible language test for candidates with SQE exemptions. Just a quick point there before we move on. The point there is, first of all, that this language test would apply when people apply for their first practicing certificate. And secondly, the point about the language test is that if you've gone through the whole of SQE without exemption, you should not need to take a language test. The language test is there for people, for example, who may be qualified in an overseas jurisdiction but exempt from SQE2. In that case, their oral English, their written English, and their understanding of spoken English have not been tested, and so we do need to have confidence of those competencies, those English language competencies, before we can issue a first practicing certificate to those candidates. So there will be an English language test, and the details of that are on our website. There's a question that's come up about going back to QWE, qualifying work experience. The questions come in about, what about somebody who's not in a training role, in a back office role but is in an experienced role? And the point about that is still that an experienced HR professional, for example, that's not about developing the competencies that you need to be a solicitor. So the point about that is that it's almost like taking a purposive view about this. Qualifying work experience is about developing the skills and competencies you need to be a solicitor, not to be an HR professional. And so it's picking up those competencies and applying them in a legal context. So the law and the application of the law and the provision of legal services is the grounding within which those competencies must be developed. And it's really thinking about that whole process of what are the skills and competencies that somebody needs to pick up to be a competent solicitor. So I hope that picks up and addresses that question. So moving on then to the next slide. This next slide picks up a slightly different position, which is not for overseas qualified or qualified lawyers, but for overseas students and trainees. And in essence, these people are in the same position as domestic students and trainees. So it's the same position, the same processes, the same requirements on them. They may have an overseas degree, and that will usually count as their degree or equivalent qualification. There is a process to go through just to check that their overseas degree is equivalent to a UK degree, and there is guidance on our website, as the slide says. Qualifying work experience, again, we picked this up earlier, it can be gained overseas, but it will need to be confirmed by a COLP or a Solicitor of England and Wales. And the SQE 1 and 2 written assessments will be available internationally, but the SQE 2 oral assessments are currently only available in England and Wales. We are doing some work around COVID actually at the moment in relation to contingency planning, so we are looking at whether it will be possible from a secure point of view to have that available internationally. I don't want to raise any expectations around that. That's a very detailed and careful piece of work that we're looking at the moment, but that is under consideration. So somebody has asked a question about qualified lawyers and the transitional arrangements. They've asked a question: if somebody has passed the MCT part of the Qualified Lawyers Transfer Scheme but not the OSCE, would they have to do both elements of the SQE to qualify? The position on that is that if somebody has passed the multiple choice question, the multiple choice test of the QLTS by the 1st of September, they are in the transitional cohort for the QLTS. So that group of people then have the choice whether or not to complete the QLTS by taking the OSCE, which they can take in 2021 to 2022, or if they haven't completed it by then, they have a further year under the transitional arrangements to complete their progression through QLTS by taking SQE2 in 2022 to 3. So I think that's the answer to that question. And then the final slide is just about the practical arrangements. A lot of this we've already picked up. We've published the planned assessment dates. I've mentioned those. They are on the SQE website. There will be a wide geographic network for the written tests. The oral skills test centres will be in London, Manchester and Cardiff. I mentioned that the SQE assessment website is now live. There is information there on bulk booking and voucher payments, and we have had some questions that have come through on this. The position in relation to vouchers, the payment is and the booking arrangements are that, first of all, the first stage is for the candidates to register, and that's when they provide personal information about themselves. That is something, because of data protection, they must do themselves. That's not something that can be done. Not sure it would even really be feasible to be done on a bulk basis, but that is something for the individuals to do themselves. When it comes to bulk payment, there is a voucher system, so firms can buy vouchers to pay for their candidates, and that they can be bought by firms or by firms' training providers, and then the individuals can book. So in fact, our steer to you is that it's most straightforward once you have bought those vouchers, for the candidates to use the codes in those vouchers then themselves to book their places on to take the SQE assessments. But it is in principle possible for firms to do that on a bulk booking system. The risk there is that if you're waiting for everybody to give you their details, to give you their registration numbers, to confirm that they have registered, etc., that you hold some people up in the system because you're waiting for somebody who's been a bit slow. So our steer to you is that actually it's probably more straightforward for you to leave that to candidates, for them to do, having provided them with the voucher codes. And the last point there is that transition arrangements are in place until 2032. We do have a very gradualist approach to this, but the point about those transition arrangements, of course, is that you've got to be in the transitional cohort. And so the last intakes in most cases for qualified law degrees and the CPE will be this coming academic year. And so that means that the CPE will come to an end really quite quickly, being only a one-year course. So that may then mean either you move all your candidates to your future joiners to the new system, or you have a mixed economy, and that obviously is going to be a difference for you. We have got a question about Wales and the fact that there are different laws in Wales and in England, and that's absolutely correct. What we expect is we expect candidates to know that and to understand that they may need to check that the position is different. In fact, the position, that Welsh law is really not substantially different in very many areas at all that are covered by the SQE. I think one that comes to mind is there's different regime for stamp duty, land tax, and different rates, I think, that apply, but we would not be expecting candidates to carry in their head different rates, knowledge of the different rates. What we might expect them to carry on in their heads is the fact that they should check which side of the border the transaction is, and therefore be aware of the needing to check what the appropriate rates are. And I've got So I've got some questions that are coming through about particular roles and what I would and whether particular roles count for qualifying work experience. What I would say in relation to that is that clearly you are the people who know what is involved in a particular role. We don't know what a particular role entails. So ultimately, it will be for you to make a judgment around your knowledge of the particular role against the guidance that we have just that I've just outlined. So it's got to be something that gives somebody an opportunity to develop some or all of the skills that they need to be a solicitor. That means, is this role developing them towards, on a trajectory and developing them towards the skills they need to operate effectively as a solicitor? So I think that's and are they directly involved in the provision of legal services? Are they doing client-facing work? Is their work firmly grounded in the application of legal principles to the law, to client-centered work? So that's the sort of approach that I think is appropriate to take. And there is something around dealing with demand. So what we are planning to do in relation to demand is we do anticipate, and we're working very hard to make sure that there will be ample capacity in the system. What I would say to you is we're very, very keen and to have a dialogue with you. So where you have visibility of numbers coming through, by all means, let us know so that we can take that into account in our planning process. We do have some mechanisms to flex capacity, when we have early insight in terms of the amount of demand that's coming through. And in relation to QLTS, we are that there is high level demand, and there is high level demand in particular jurisdictions. As many of you know who have offices in that jurisdiction, particularly Hong Kong it has particular difficulties at the moment given the political situation there. But we have we have found capacity for QLTS. So QLTS candidates have been able to sit, and that process has been managed effectively to date. So we are anticipating that there will be capacity. There are mechanisms for us to flex capacity, but please do keep us in the loop and give us advanced insight in terms of what you are seeing in terms of capacity or demand coming through. So I think that's it, Ben. That may have been a little bit longer than planned because I was trying to pick up some of the questions that came through, which I have to say slightly distracted me from time to time. So hopefully I have picked up most of the queries that have been raised.
No problem. Thank you, Julie. There are one or two others that will go back through while you catch your breath. And please do, for people who, as Julie has been talking, please do continue to submit your questions through clicking on the link, and they will make their way to us. We do have probably a few points that were not sort of implicit in what you were saying about the nature of QWE. So the first question that's come through is, does it have to be 2 continuous years of QWE, or can it be over a longer period with breaks in between?
Yeah. Thanks, Ben. Yes, it does not have to be 2 continuous periods of qualifying work experience. So it can be over a longer period if a candidate has taken a break. Absolutely.
And thank you, Julie. And the second one, and I know this sort of something that we as a firm have always sort of grappled with over many years, is the under the current PRT requirements, there is a requirement for contentious experience. How's that going to look in the SQE world?
Yeah. First of all, we've moved away. In fact, we've already moved away, as many of you will know, from requiring particular experience of 3 particular practice areas, or contentious and non-contentious. And similarly, under QWE, it's very competence based. So when you're looking at developing the competencies during the period of QWE, the reference point is the Statement of Solicitor Competence. And we do have a template on our website to guide candidates and employers in terms of good quality qualifying work experience and developing the full range and the breadth, which would mean a sort of very good experience of qualifying work experience. But it is very much more based around competencies rather than particular practice areas. So there isn't the requirement specifically for contentious experience, but there is a requirement, for example, or included within those elements are things like advocacy. So a broad, good quality work experience would cover the whole of that range, but there is no specific requirement for all of those to be covered. What I would say to people is as you know, do give your candidates as broad an exposure as possible so that they can meet those competencies, and that is what they will be assessed on. So they will have to demonstrate that they are competent in all those areas through SQE1 and SQE2, and it would be good for qualifying work experience to be aligned around those areas.
Thank you, Julie. So one other point I think is just worth clarifying. I think you already referred to this when you mentioned that the SRA website was live and enabled people to log qualifying work experience now. But it follows from that, as I understand it, that work experience that's being done now can be counted for SQE purposes.
That is correct, yes. So we don't have any cut-off date historically for when qualifying work experience has to have happened. People can already be collecting it and logging it. And as I said a moment ago, that's why we thought it would be helpful to open qualifying work experience even before the regulations went live. I think we've had another question come in, haven't we, Ben, about what happens if there's an unresolvable difference of opinion between an employee and employer as to whether the employee's role constitutes QWE. And the first thing that I would say about this is that if it meets our requirements, then the employer should sign it off. So it should be, in most cases, we expect a straightforward process. But we have got an opportunity once the SQE regulations go live for people to contact our SQE helpline or QWE helpline to should there be an issue like this, to get some guidance from the SRA on that point. So there will be some support available to help resolve those difficulties if there is a difficult issue there.
Just to go in a slightly different direction for a moment, Julie, if I may. One of the things I know sort of we've been talking about through the CLS training committee with you for some years around SQE1 and SQE2 is that there really are two different ways for candidates and for firms to approach this. The sort of first approach, which a number of the firms who've already sort of put in place their implementation plans, is to sort of have all of the both sets of exams be taken before the person starts in the workplace doing their QWE, and the second is to have the person sit the SQE2 at an unspecified point during the QWE. You haven't specified when SQE2 needs to be taken, so both both approaches are possible, and I think we probably expect to see people adopting both approaches in the market. Firstly, do you have anything further to sort of say on that subject? And second, there is a specific question that's come up around situations where a firm may send someone off for a period of a few weeks on a prep course to prepare for their SQE2, where the person hasn't already taken SQE2 prior to starting the workplace. So,
oh yes,
yeah.
So the first point in relation to the timing is that we did ponder very long and hard about this. I mean, as Ben says, I think we debated it on a number of occasions, didn't we, Ben, at the CLLS Education Training Committee. Ultimately, we felt that it's our role to be confident at point of admission that candidates are competent. It's not our role to unnecessarily specify the particular order or the manner in which people develop those competences. So we felt that different people wanted to take different approaches, and you know, that was for them to manage the process appropriately. You're right, I think, that we will probably see a mixed economy on this. I think we will see some firms, certainly at the beginning, having their people take SQE1 and SQE2 before they do their qualifying work experience. Others are taking a much more integrated, holistic approach of integrating training and assessment and work experience within one package. And the risk, I guess, is that the standard is the same. So the standard is day one of a post-admission qualified solicitor. It's not day one of a trainee solicitor. So it's not the current LPC standard for SQE2 and for those skills. It will be day one of a qualified solicitor. So what we will be looking for is actual competence to a day one standard. And if you think about the journey that your trainees commonly make from day one, you know, of seat one to the last day on seat 4, it's that standard at the end of that process which SQE2 will be assessed towards. So you know, that's the standard of assessment, and you know, we will see how systems emerge and what works effectively and what works less effectively, you know, and that will I think probably evolve over time. The other issue was in relation to time off during the 2 years qualifying work experience and the length of time for that. Qualifying work experience does not include simulations or classroom training, but nor do we count days. You know, we have left this at the discretion and the sensible, reasonable discretion of the COLP and the person confirming that 2 years qualifying work experience has been completed at the end of that process. Now, there's always going to be a little bit of give and take around that. You know, somebody may be off sick for two weeks. That doesn't necessarily mean you have to expand the period of qualifying work experience. If somebody goes off and takes a 2-month course to prepare themselves for SQE2, I think that is probably a different in degree. But you know, taking a day off, a couple of days off for to take an assessment, that may not invalidate, you know, or require an extension to the period. But it's, what I would say is, I don't want me to be making a decision for you. It is your decision when the person is signing off qualifying work experience to look at the totality of that person, to see what their experience has been and whether that constitutes 2 years full-time equivalent qualifying work experience, bearing in mind that qualifying work experience is workplace experience. We've been very clear to those apprenticeship providers that have 1 day a week off out of the workplace, that 1 day a week doesn't count towards qualifying experience. But you know, the odd day here or there, the odd period of sickness, of course, that's part of the, you know, the rough and tumble, if you like, of working life.
Thank you, Julie. Just one other point I think is probably worth emphasising as we talk about sort of the different demands on people during QWE as compared to the current PRT regime, which is, as we all know now, we're dealing with a situation where people start the PRT and then they have to go through various PSC courses over the 2 years. And just to confirm that the additional add-on PSC aspects are no more under the under the new system.
That's quite right. Yeah. No, indeed. So PSC will no longer exist.
Okay, we've had a couple more specific questions come through. One is around the sort of the situations with paralegals or legal assistants, and how their their roles and job titles may be affected by taking the SQE. So
yes.
Perhaps you could.
Yeah, that's right. So this is this thorny question, which we have sort of given quite a lot of thought to, and I think sort of developed our position on this, which is about what happens where you have a paralegal who qualifies under the SQE, is admitted as a solicitor. So they put in their application as a solicitor. What happens to them? It may be that you don't have a solicitor role for them. So what happens to them? So the position is that if they've applied to us for admission as a solicitor and they have been admitted as a solicitor, then they should describe themselves as a solicitor, because that is what they are. But you do not need to employ them or pay them as a solicitor. That's entirely, your terms and conditions are entirely a matter for you in terms of employment, your employment contract. But they are admitted as a solicitor, and therefore they do need to describe themselves as a solicitor.
Okay. There are a couple of different other questions. One I'll come on to because it's an area we haven't discussed yet, is about reporting and record keeping requirements on firms in relation to signing off QWE.
Yes, I think that's a helpful question to come through. So I mentioned that we've got a template on our website in terms of to give people an opportunity to record what they have been doing, and I think some of that is an opportunity to make sure that, for instance, as an employee, you are gathering evidence of what you have been doing over time, and that can help in the confirmation process that you have had an opportunity to develop some or all of the competencies needed for practice as a solicitor. The other question, I think the specific question, has come through about timing, and again, similarly, so that template does not need to be submitted to. Sorry, I lost my train of thought. That's a matter for you, and to helps you as employers and your employee candidates record what's happened. But that's for your processes. It doesn't need to come into us. Similarly, insofar as time is concerned, the person signing off needs to put themselves in a position that they are confident that the person has had the opportunity to develop the competencies, and that they have spent the time claimed for. And so that's a matter for you to have the internal systems and processes, and to meet your obligations as a solicitor, to satisfy yourselves that you are confident on a person by person basis that the requirements for qualifying work experience have been met. We don't need to see that. So the confirming solicitor or COLP will sign that off, confirm that to themselves, and can confirm that to us when they confirm QWE, and we don't need to have sight of that, of those internal systems as part of that sign-off process.
Thank you, Julie. And there's a separate follow-up question that has come up relating to the topic that we spent time on earlier, which is around the sort of individuals within firms who are not involved in the provision of legal services.
Yes, that's right. I think the follow-up question was, will we update our written guidance? And the answer to that is yes. We have got this in the our work as the guidance evolves and develops. We will add this into that. Yes.
And separately, jumping a little bit back and forth, back to the paralegal question, someone has specifically asked whether or they've put it to us that so there is no requirement for paralegals who have qualified through the SQE to take themselves off the role of solicitors while employed as a paralegal in our firms.
That's right. That's where we that is something that we did used to suggest, and we've gone back and thought again and looked at the statutory framework, and we don't think that that is necessary. So we hope that sort of eases things for everybody concerned. That doesn't mean to say that you need to employ them in a solicitor role, but they would need to describe themselves as a solicitor. But it's up to you as a matter of your relationship with them, the nature of the work that you give that person to do. I think we've had another question come through. I think Ben has just frozen. I don't know whether that's for everybody, but I think we've had another question that's come through, which is, do we have a working idea of what the pass rate will be for SQE1 and SQE2? We don't have quotas, and I think that's the most important high-level message to give on that. So what we do is we have a standard that people must reach in order to pass SQE1 and SQE2. We have partly statistical, partly judgmental ways of making sure that we apply that method consistently. We have panels of solicitors who are with necessary expertise who will be involved in making those judgments around what the standard is. So there's not a fixed pass mark, and nor is there a fixed quota of candidates who will come through. It'll depend on the numbers of people who properly meet the high professional standards that we will set through SQE for admission as a solicitor. I think we've still lost Ben, unless he's coming back to us. And I am not sure whether there are any other. I'll see if we've got any other questions that I could usefully pick up while we're waiting for Ben to join us. Oh yes, I had a question that had been, I think, come through previously about how will. Well, two questions. First of all, how long will it take for results to come through? And secondly, how will the bookings be managed? It goes back a little bit to what we were talking about before. First of all, in terms of results, this information is on the SQE website, but the results for SQE1 will take 6 to 10 weeks to come through, and the results for SQE2 will take 14 to 18 weeks. Now, we've given a range there for two reasons. First of all, because sometimes, as in the first sitting of SQE1, you have bank holidays that are in the middle of that results process. So we've got Christmas coming up following the first sitting of SQE1, so that obviously lengthens that process. But also, we're being quite cautious around this, in that we anticipate that in early days it may take a little longer for us to go through these processes. We may be able, as things become increasingly familiar BAU, we may be able to shorten that process, and where we can do that, we will. But obviously, the most critically important thing is to make sure that those are absolutely accurate, and the necessary checks are gone through scrupulously. So that process the results process may get shorter over time, but that's the thinking at the beginning. Now, the other question was in relation to how will exams be managed? Will it be first come, first served? The answer to that is yes, it will be first come, first served. But as I said in response to the earlier question, we do anticipate having sufficient capacity in the system. There will be ways for where we see larger numbers perhaps coming through, particularly in relation to SQE2, for us to flex that and add capacity into the system where necessary. So we have a little bit of flexibility around that. Now, I still don't have Ben. I'm I think I've pretty much run out of questions which have been posted earlier. So unless there is a further question from anybody to come through, I wonder whether now might be the right. Oh, hang on a sec. No, I've picked up that. Oh, here's Ben. Ben, you just came through. I was just wondering whether I would draw matters to a conclusion. So I'm sorry to have lost you there for a moment or two.
That's no problem. I managed to be kicked out of the meeting due to some local internet difficulties at my end. But it sounds like we've been through the questions. If there are any more questions, please do send them in now. If not, then I'd just like to close. Firstly, again by thanking Julie for her time today and for the very informative answers that she's given. There's one last late-breaking question though before we wrap up completely. So.
Yes. And in fact, I'm pleased to be able to address this question. So we've had a question about assistive technology, and the way that it's been put, and I can understand why it's been put in this way, because this is the way that it's been reported, is that our position on banning assistive technology seems to go against our aims of increasing diversity and inclusion in the profession. And I think the reason I'm glad to be able to put the record straight on this is that we are not banning any assistive technology. That would not be appropriate, of course. So there are already a number of forms of assistive technology that we have in place as an anticipatory adjustment in relation to the SQE. We're looking at other anticipatory adjustments that can be put in by way of assistive technology. But obviously, for each person that comes through, we look at their position on an individual by individual basis to see what the appropriate reasonable adjustment is for that person. So I'm very glad to put the record straight on that one. We have another question there coming through.
Through again, actually. Oh,
so
now.
Hang on a sec. I'm just slightly struggling to pick up the question here. Bear with me a second. Where a back office is internally provides legal services. Okay, so I think this is another question on QWE, which is probably a question that we've covered previously, Ben, on back office roles. I think we've already covered that one off, actually.
Okay, great. Well, with that, I was going to close today's session, thanking Julie once again for the time, as well as the very constructive and candid answers that she's given, and to give one public service message, which is that there is a feedback form. I believe you will find it on a link below the videos of us, and both the SRA and CLLS would like to hear what you thought about this webinar. Was it useful, and what you would like to see covered in the future? And if you click on that link, you will find a short survey to complete, and it will only take you a couple of minutes to do so. So once again, thank you to Julie, thank you to everyone for participating, and thank you for the engagement and the questions, and have a good rest of the day.
Yeah, thank you, Ben, and thanks everybody.